from states and individuals. He invented the concept, and by genocide, he wrote, we mean the destruction of a nation or of an ethnic group. This occurred, he continued, as a composite of different acts of persecution or destruction. And on his interpretation, they occurred in two phases. One, these are his words, destruction of the national pattern of the oppressed group. The other, the imposition of the national pattern of the oppressor. And he continued, the oppressed who were the subject of genocidal acts could remain or they could be removed. The oppressed were always members of certain national groups who lived as minorities. And I quote him, if these groups should not be adequately protected, such lack of protection would result in international disturbances, especially in the form of disorganized emigration of the persecuted who would look for refuge elsewhere. End of quote. And against this background of what he saw between 1933 and 1945, he proposed, quote, an international multilateral treaty should provide for the introduction of provisions protecting minority groups from oppression because of their nationhood, religion, or race. The 1948 Convention is that international multilateral treaty. And Lemkin's words, written in 1944, and Article 2 of the 1948 Convention capture, regrettably but exactly, what has happened to the Rohingya. Lemkin's assessment back in the 1940s was the product of a meticulous exercise of research and reflection. His book and the Convention are testament to the power of ideas, to their reduction into a written and legal form, and to their capacity to hope for the world as a better and safer place. Raphael Lemkin lived through terrible times, just as the Rohingya have. But at no point did he, or his colleague Hirsch Lauterpacht, or so many others like them, choose to curl up in a corner and weep, or conclude that action or international rules were pointless. And the Rohingya have adopted exactly the same approach. And so has the Gambia, whose Attorney General you heard from this morning. That is why the Gambia is here today. Mr. President, the Genocide Convention, including its Article 2, really matter. And so does its meaningful and effective interpretation and application on the facts of this case to the situation regarding the Rohingya. It's to that issue that Mr. Reichler will now turn, and perhaps after a brief pause, you would call him to the bar. I thank you for your attention.
I thank Professor Sands. Before I give the floor to the next speaker, the court will observe a break of 50 minutes. The hearing is suspended. followed by cross-examination of the expert by Myanmar, which would be confined in scope to statements already made by him as part of his written statement or reports, and re-examination by the Gambia, which would in turn be confined to matters arising as part of the cross-examination. Following re-examination, question could be put to the relevant witness or expert by the President on behalf of the court or by individual judges. The witnesses and expert would respond orally and without delay to any question put by the parties or by the judges, except in particular circumstances, for example, when specific information was requested that needed to be verified. In order to ensure the safety of the witnesses called by the parties, the court decided that they would be heard in closed sessions, with only judges, registry staff, interpreters, technical personnel, and members of the delegation on the official list provided by each party to the court being allowed in the courtroom during the in-camera sessions. The parties were also informed that the court had agreed to the use of pseudonyms when addressing the witnesses called by the parties or when referring to them at the hearings. By a letter dated the 18th of November 2025, the Gambia provided written affidavits of its witnesses as well as the written statement of its expert. By a letter of the same day, Myanmar informed the court that it intended to call only one witness and reserved the right to call a different witness if for any reason the former should be unavailable to testify. Myanmar also provided confidential written affidavits for both of these witnesses in the Myanmar language, accompanied by certified translations into English. It further indicated the pseudonyms that should be used for these two witnesses. After ascertaining the views of the parties, the court decided, pursuant to Article 53, Paragraph 2 of its rules, that copies of the pleadings and documents annexed in their redacted versions as appropriate will be made accessible to the public on the opening of the oral proceedings, except for certain annexes that will be kept confidential. In addition, with regard to written pleadings and documents annexed, which contain written statements and accounts given by the witness called by the parties, as well as the redacted version of the affidavit of witnesses and the verbatim record of their testimonies, it was decided that these materials would only be posted on the court website after the end of the oral proceedings. The court also decided to make accessible to the public, on the opening of the oral proceedings, the reports submitted by Myanmar on the measures taken pursuant to subparagraph 4 of the operative clause of the order on provisional measures of the 23rd of January 2020 and the Gambia's comments on them. In this respect, the court notes that our parties were consulted on this matter and did not object to such publication. Further, after consulting the parties and the intervening states, the court decided to make accessible to the public, on the opening of the oral proceedings, the written observations of the parties on the declarations of intervention pursuant to Article 83, Paragraph 1 of the Rules of Court, the written observations of the states seeking to intervene, and those of the parties on the admissibility of the declaration of intervention in accordance with Article 84, Paragraph 2 of the Rules of Court, as well as the written observations of the intervening states, referred to in Article 86, Paragraph 1 of the Rules of Court on the subject matter of their intervention. I note the presence in the court of the agents and counsel of the two parties. In accordance with the arrangement for the organization of the proceedings which have been decided by the court, the hearings will comprise a first and second round of oral argument. The first round will begin today with the oral pleadings of the Gambia and will close on Tuesday, the 20th of January 2026, following Myanmar's first round of pleadings. For the first round, each party will have 6 sessions of 3 hours at its disposal. The second round of oral argument will begin on Monday, the 26th of January, and conclude on Thursday, the 29th of January. Each party will have 3 sessions of 3 hours to present its reply. In addition, the court will hear witnesses and experts between the 2 rounds of oral argument. The witnesses of the Gambia will be heard in 3 closed sessions on the morning and afternoon of Wednesday, the 21st of January, and on the morning of Thursday, the 22nd of January. The expert called by the Gambia will be heard in open session on Thursday, the 22nd of January at 3 p.m. The witness called by Myanmar will be heard in closed session on the morning of Friday, the 23rd of January, 2026. In this first sitting, the Gambia may, if required, avail itself of a short extension of time in view of the time taken up by my introductory words. I now give the floor to the agent of the Gambia, High Excellency Mr. Dawda Jallow. Sir, you have the floor.
Mr. President, esteemed judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. 6 years ago, the Gambia filed its application with this court, seeking to hold Myanmar accountable for its violations of the Genocide Convention. In January 2020, you ordered provisional measures and did so unanimously. We are now finally in the merits hearing, after which the court will decide whether Myanmar is responsible for acts of genocide against the Rohingya group, as alleged by the Gambia. As you will hear over the next 3 weeks, and in particular over the next 4 days, in deciding to bring this case, the Gambia acted on the basis of most careful reflection and assessment of the facts. We did not bring this case lightly. We brought this case after reviewing credible reports of the most brutal and vicious violations imaginable inflicted upon a vulnerable group that had been dehumanized and persecuted for many years. We received and carefully examined the meticulous reports of the United Nations fact-finding mission, dispatched by the UN Human Rights Council. We also examined reports issued by the reputable international human rights organizations, which sounded the alarm on the genocide of the Rohingya unfolding in northern Rakhine State. Those credible reports from diverse and independent sources left no doubt in our minds that Myanmar had to be held accountable for its violations of the Genocide Convention. And so we acted. Genocide Convention is the first multilateral human rights treaty that have been adopted. But its words will be meaningless unless they are acted upon and enforced. It is up to the state parties to the Genocide Convention to invoke affirmatively its provisions in order to truly liberate mankind from the odious scourge that is the crime of genocide. That is why the Gambia invoked Article 9 of the Convention and brought its dispute with Myanmar to this honorable court. The Gambia stands tall in the international community of states and takes pride in promoting and protecting human rights, including international accountability for genocide and other atrocity crimes. We do this out of sense of responsibility, grounded in the history of which we too suffered under a military junta. Over 2 decades of brutal dictatorship have taught us that we must use our moral voice in condemnation of oppression, of crimes against individuals and of groups, wherever and whenever they occur. It is also taught to us that accountability is imperative. Otherwise, impunity will ensure that such crimes are repeated over and over. In present times, these issues are more important than ever. And the court's role is more important than ever as a bastion for the rule of law. Sadly, Myanmar appears to be trapped in a cycle of atrocities and impunities. Nobody has been held responsible for the crimes against the Rohingya. Indeed, the military that perpetrated the genocide actually felt emboldened to overthrow the civilian authorities again. Myanmar's original agent in this case, the former state councillor, Madam Aung San Suu Kyi, has been imprisoned by the military junta, deprived of her liberty since she was swept from power by the same generals who continued to rule the country. And Senior General Min Aung, who commanded the military during the genocide, now rules over Myanmar as the leader of the junta. Predictably, violence and atrocities have spread through in Myanmar nationals of all ethnic groups. It is the only applicant state. We are not alone in. Indeed, as the General Assembly stated in 1946, genocide sucks the conscience of mankind and results in great losses to humanity. And this is because humanity is made of various groups. This is why we stand before you with full backing and support of 57-member organization of Islamic cooperation. We also stand in solidarity with 11 intervening states from across the world.
its provisions. and so it is today. That purpose and those ideals inform the way in which the court interprets and applies the provisions of the conventions in this case. The court's jurisprudence on the convention, in particular with the Bosnia and Croatia judgments of 2007 and 2015 respectively, is the lodestar on which the Gambia's application has been based. Other aids to interpretation, including the jurisprudence of the international criminal tribunals and national courts, and it is worth mentioning that in particular it is the courts of Germany that have in recent years played the leading role that a situation of armed conflict does not preclude the crime of genocide. Second, the Convention does not require that a genocidal intent be the sole motive pursued by a respondent state or its agents, but it permits of multiple and overlapping motives. Third, a genocidal intent does not have to be expressly stated and may be established or inferred either from particular circumstances or a pattern of behaviour or conduct. And fourth, the requirement that a substantial part of the protected group is targeted forcibly transferring children to another group. Any one of these acts committed with the requisite intent is sufficient to constitute the act and the crime of genocide. And my colleagues will take you to evidence over the course of this week which will show many acts falling within the first four categories of Article 2 having been committed by Myanmar against the Rohingya group. In the counter-memorial, Myanmar argues that the number of victims is relevant to the determination of whether the actus reus of genocide has been committed. carried out. This is because it may, but not necessarily, it may bear on whether there is a reasonable inference that acts were carried out with the specific intent to destroy the group. That aspect of establishing the existence of the mens rea of genocide is a point to which I will return on Wednesday, to be followed by Mr. Reichler. But to be clear, there is no numeric or substantiality threshold inherent in the actus reus. As this court has observed, and the chapeau of Article 2 makes plain, there are, and I quote, two constituent elements, end of quote, to genocide. Undoubtedly have occurred in this appalling case. It has to be underscored that the other modalities of the actus reus are just as central to the Gambia's case as acts of killing. Prominent in this case are acts falling within the scope of Article 2, paragraph B, causing serious bodily or mental harm to members of the group. The kinds of acts falling with this category are sadly diverse in this case. They include acts of sexual and gender-based violence, acts causing physical and psychological harm, and acts